and welcome back to the channel. If you haven't already, before watching this video, it's a good idea to watch the introductory video on protection of minority shareholders. In this video, we're going to look at personal actions as well as an action called the derivative action available to minority shareholders. So today's focus is on two remedies. Firstly, personal actions. That is where you enforce your own rights as a member of the company. And secondly, the derivative action. This is where you step into the company's shoes to enforce the company's rights when those who control the company refuse to act. We'll connect these with the broader toolkit that I've already told you about in the introductory lecture. And we'll also connect that with a further video which I'm going to make available on the unfair prejudice petition. And in extreme cases, there's the nuclear option of a just and equitable winding up. But our emphasis here is choosing wisely between personal and derivative routes. Here's the simple question to start with. Has a personal right of the member or the shareholder been infringed? If yes, then consider a personal action. In some cases, an unfair prejudice petition under section 994 of the Companies Act 2006 may also be appropriate if the overall conduct is unfair. If the answer to the question, has the shareholder's personal rights been infringed, is no, in other words, if the harm is to the company, then consider a derivative action under sections 260 to 264 of the Companies Act 2006, which is aimed at enforcing the company's right against the wrongdoer, which is often a director. If the relationship has completely broken down or there's a deadlock, the winding up on just and equitable grounds under section 122 of the Insolvency Act 1986 may be the last resort. Please take note that the unfair prejudice petition overlaps, so it can be used in instances where the shareholder's personal rights have been infringed, but it could also be used if the shareholder's rights have not been infringed, but the harm has been caused to the company itself. So the decision turns on who suffered the loss and whose right was infringed, with the proviso that the unfair prejudice petition overlaps those two. With the exception of multiple derivative actions, the Companies Act 2006 has replaced the common law derivative action with a statutory derivative claim, which is contained in sections 260 to 264 of the Companies Act 2006. So the derivative claim is a claim brought by a member under those sections against a director for an actual or proposed act or an omission involving negligence, fraud, breach of duty, or breach of trust. The claim is brought by the member, but it is brought for and on behalf of the company itself. An unfairly prejudicial conduct petition, on the other hand, alleging the company's affairs have been conducted in an unfairly prejudicial manner, is brought under section 994 of the Companies Act. Normally, if such a petition is granted, the court orders purchase of the petitioner's shares. And finally, proceedings may be brought under the Insolvency Act 1986. A personal action enforces a right that you have as a member under statute, the articles, or a contract. Classic examples of these include being wrongly refused your vote at a meeting or even notice of a meeting, being denied a dividend that was properly declared, being refused inspection of registers or documents where statute gives you that right, and under section 33 of the Companies Act 2006, remember that the company's constitution forms a contract between the company and its members. If the company breaches a term conferring a right on you as a member, you can sue personally for that breach. Please take note that a reflective loss, you generally cannot claim compensation for the fall in value of your shares or the loss of dividends, where the company is the one that was directly harmed. So in other words, a reflective loss refers to your loss that is a reflection of a harm that befell the company. So let's say that the company is in financial difficulty and the share price drops. If you then have a loss because of your share, the shares, you've paid more for your share than what it is worth now, that loss reflects what is going on in the company. that is a reflective loss. So the loss is reflective of the company's loss, and as such, you cannot claim on that. If the company suffered a harm, it's for the company to pursue whatever claim is necessary to rectify that harm. Now, this is very well illustrated in the case of Prudential Assurance versus Newman Industries in 1982. The fact of this case was that the directors of Newman Industries issued a circular to shareholders recommending approval of a company transaction, which was the purchase of another company in which two of the directors had a personal interest. The circular, however, contained misleading information, and the shareholders, relying on that misleading information, voted in favor of the transaction. Prudential Assurance, which was a minority shareholder, later then sued the directors for breach of duty and deceit, claiming that the company itself had been defrauded and that shareholders had been misled. The issue before the court was, could an individual shareholder bring an action to recover losses arising from a wrong done to the company? In other words, can they base a claim on the fall in value of their shares? The Court of Appeal held that only the company could sue for a wrong done to it. A shareholder cannot bring a personal claim for loss merely reflecting the company's loss. This would be a reflective loss and it's not claimable. The misleading circular had injured the company, not the shareholders directly. However, the directors were indeed held liable to the company for their breach of fiduciary duty. So the principles that we get from this case, firstly, is the reflective loss rule. A shareholder cannot personally recover for loss that merely mirrors the company's loss. So where directors commit a wrong against the company, it is the company, not the individual shareholders, that must bring any proceeding. This, of course, you'll remember, is the rule that we got from Foss versus Harbottle. The company is its own person and it has to pursue its own actions. Shareholders can only pursue such actions on behalf of the company under a derivative action, which we'll look at in a second. So in short, Prudential Assurance versus Newman established that shareholders cannot sue in their own name for losses that stem from harm done to the company. Only the company itself can seek redress. The judgment said, I quote, "What a shareholder cannot do is to recover damages merely because the company in which he is interested has suffered damage. He cannot recover a sum equal to the diminution of that means the shrinkage, in the value of his shares or equal to the likely diminution in dividend, because such a loss is merely a reflection of the loss suffered by the company. The shareholder does not suffer any personal loss. His only loss is through the company in the diminution, the value of the net assets of the company." So let's just pause again on the concept of a reflective loss and why it matters. The prohibition of pursuing a reflective loss stops multiple actions and double recovery. If a director's breach injures the company, the correct claimant is the company, not each shareholder. Your drop in share value is a knock-on effect of the company's loss. Practically, this channels corporate wrongs into company-level remedies, including derivative claims, rather than fragmenting them into lots of individual member claims. So let's dive into derivative actions. A derivative action lets a member enforce a right belonging to the company when those in control of the company won't act. You are not suing for yourself, but deriving your standing from the company's cause of action. The typical content or the typical context in which this would happen would be where, for example, directors have committed a breach of duty, such as negligence, default, or breach of trust, and the board won't sue, perhaps because the wrongdoers control the board or the general meeting. The modern route for this is the statutory derivative claim under the Companies Act 2006. Section 260 replaces the old common law procedure. So we did have the derivative action under the common law, but it's been simplified and codified into Section 260 of the Companies Act 2006. It works like this. A derivative claim may be brought only in respect of a cause of action arising from an actual or proposed act or omission involving negligence, default, breach of duty, or breach of trust by a director of the company. There are two key features of this action. Firstly, the claim is on behalf of the company. In other words, any remedies that may arise out of a successful claim will go to the benefit of the company. The shareholders are not suing for their own benefit. They're suing for on behalf of the company for the benefit of the company. The second key feature is that the claimant needs the court's permission to continue the claim. That permission stage filters out weak or tactical claims. So in effect, this means that for every derivative action, there will be 2 court hearings. The first to obtain permission, and the second is then to litigate the substantive issue, such as, for example, if there's an allegation that a director was acting negligently. Let's start with the first hearing, namely to obtain the court's permission to pursue the substantive derivative claim. At the permission stage, the court assesses whether the claim should proceed. It's only once that permission has been given that the claim then actually does go ahead. Now, at the permission stage, key considerations include, firstly, good faith. Was the claimant acting in good faith? So is the application genuine, or is it primarily tactical? Then, Section 172 gives us the so-called notional director test. This is very similar to the reasonable man test that we have in tort. The notional director test asks, would a hypothetical honest director acting to promote the success of the company pursue this claim? If not, if such a notional director would not pursue such a claim, then the court will refuse permission. Also, going back to good faith, if the claimant isn't acting in good faith, the court will not give permission for the action to proceed. Then the court looks at whether or not there's an alternative remedy. Could the member reasonably pursue relief any other way? For example, through a personal action, or for example, through an unfair prejudice petition. If so, permission will be refused and the court will say, pursue it using this other avenue available to you. Then, fourthly, ratification. The court asks, would the company be likely to ratify the conduct complained of? If the company is likely to ratify the conduct complained of, permission would not be granted because it would make no sense litigating something that the company will then just turn around and ratify anyway. Then finally, the court will also look at what is in the company's best interests, considering costs, disruption, prospects for success, etc. In other words, is litigation sensible for this company? The court can also consider proportionality, the chances of success, and whether the claim is essentially a dispute better handled under unfair prejudice, which we'll look at in the next slide. So, taking into account all of these considerations, the court decides whether or not the claimant will be allowed to pursue the derivative action. So the derivative action could be anything on behalf of the company. It could be a claim against directors who have breached or who were alleged to have breached their directors' duties, right? So firstly, you've got the hearing for permission, and then secondly, you've got the substantive derivative action, which is the claim itself. Let's look at a few examples from case law showing when the courts have and haven't allowed derivative claims to continue. First up, Mission Capital PLC versus Sinclair, a 2008 case. This case involved directors accused of diverting company funds to their own benefit. The shareholder wanted to bring a derivative action on the company's behalf. However, the court refused permission and said the company could have ratified the director's conduct, and in any event, the shareholders' motives seemed more personal than genuinely in the company's interests. Next, Franbar Holdings versus Patel. We'll look at this case in a lot more detail in the next slide. Eseni versus Westrip Holdings Limited, 2009. I hope I've pronounced that correctly. This is a leading authority on how to apply Section 263. The shareholders alleged that directors had made disastrous business decisions that damaged the company. But the court said poor decisions alone aren't necessarily breaches of duty. The court applied the hypothetical director test, which we've just looked at, asking whether an independent, honest director might think continuing the claim was in the company's best interests, and decided that no reasonable director would, so permission to pursue the claim was not granted. Finally, we have Kiani versus Cooper, a rare example where permission was granted. Like with Franbar, we'll look at this case in more detail in a minute. So in short, permission is the exception, not the rule. The courts will only allow a derivative action to continue when it's clearly in the company's best interests and not just a way for shareholders to air personal grievances. So let's look at Franbar Holdings versus Patel. This case was one of the first to apply the new statutory rules on derivative claims under sections 260 to 263 of the Companies Act 2006. The background was a dispute between two shareholder groups in a medical centre business called Medicentis UK Ltd. In 2005, Franbar Holdings, who was a shareholder, was the owner of Medicentis, sold 75% of their shares of Medicentis to Casualty Plus Ltd under a shareholders agreement that also gave both sides options over Franbar's remaining shares. So that would mean that Franbar then became a minority shareholder. Relations later soured after Mr. Patel joined the board. So Mr. Patel being appointed the director and member of the board. Franbar, being by then the minority shareholder, accused the majority shareholder and two directors, Mr. Patel and Mr. Van Rooyen, of diverting business opportunities, excluding Franbar's representative from management, and generally mismanaging the company to drive down its value. So if the value of the company was driven down, that would mean that Casualty Plus Limited, who had the option to buy the rest of Franbar Holding shares, would be paying less for those shares. Right. So Franbar, minority shareholder at this stage, therefore brought three parallel actions. Firstly, a derivative claim on the company's behalf. Secondly, an unfair prejudice petition under Section 994, and a contractual claim under the shareholders' agreement. The court refused permission for the derivative claim to continue. The judge in this court accepted that some allegations were arguable, but the real question was whether continuing this separate action was in the company's best interest. The judge held that it was not. The alternative, an unfair prejudice petition, could already give complete relief, especially through a buyout order valuing Franbar shares as if no wrongdoing had occurred. So that driving down of the share price being discounted. The court said that running both claims side by side, in other words, the derivative action in tandem with the unfair prejudice petition, running both of these claims side by side would simply add costs and duplication, and you wouldn't be able to recover the same loss twice. So Franbar versus Patel stands for the principle that the court will refuse derivative claim where another remedy, particularly unfair prejudice petition, can effectively address the alleged wrongs. So here we see derivative actions are the exception, not the default. It's quite difficult to get permission to pursue a derivative action, especially if there is a better alternative. In this case, the unfair prejudice petition. Now let's look at a case where the derivative action was, or permission was granted to pursue a derivative action, namely Kiani versus Cooper. This case shows the court's willingness to grant permission for a derivative claim where there is clear evidence of serious director misconduct and no alternative remedy that would do justice. Mrs. Kiani and Mr. Cooper were the only shareholders and directors of a small property development company. Each owned half the shares, but relations broke down when Mr. Cooper claimed that the company owed him large sums, and he even sought to wind the company. Ms. Kiani alleged that those payments were not loans at all, but capital contributions, and that Cooper had diverted company money to his own entities, including a firm called DPM Property Services and another, which she said he secretly controlled. He had also allowed DPM to obtain a default judgment against the company for work and overhead charges that were never agreed, effectively suing himself on both sides of the case. So Ms. Kiani applied under sections 260 to 263 of the Companies Act for permission to continue a derivative claim on the company's behalf. Judge Proudman held that there was strong evidence of breach of fiduciary duty, that he was acting in good faith, and that a reasonable independent director acting under section 172, so that's that notional director, would indeed continue the action, given the seriousness of the alleged misuse of the company's funds. So although Cooper argued that an unfair prejudice petition under section 994 would be a better remedy, the judge said that that was merely one factor, not decisive. She therefore granted limited permission for the claim to continue down to disclosure, allowing the facts to be properly tested. So Kiani versus Cooper illustrates the court's balanced, fact-sensitive approach. Derivative claims are exceptional, but permission will be granted where credible evidence of self-dealing and conflict of interest makes corporate litigation genuinely in the company's best interests. So to recap and to conclude, usually any claim by the company lies with the company itself. This is the majority rule principle, which we got from the classic case of Voss versus Harbottle. So what can you do if you are a minority shareholder? First off, there's the personal action, where you enforce your own member rights. These membership rights would be voting rights, dividend rights, etc. You cannot recover what we call a reflective loss. Then we have the derivative action. This is where you enforce a company's right where the controller, the people in control of the company, won't act. For a derivative action, firstly, permission is required, and the courts filter claims using the criteria set out in section 263. Then there's an unfair prejudice petition under section 994, which we'll look at in a separate video. And this is where when the bigger picture is ongoing unfairness in how the company is run. And finally, there's the nuclear option of a winding up petition under section 122 of the Insolvency Act 1986. And this is reserved for when relations between the company and the shareholders and the directors have broken down beyond repair. So the art is choosing the right remedy or the right action to pursue from the outset. That's our overview of personal and derivative actions. Thanks for watching, and don't forget to check the earlier lectures in this series if you need a refresher, and the following lecture, which is on the topic of the unfair prejudice petition. If you found this useful, don't forget to like and please subscribe. See you in the next one.